Okay, everyone. All right. So, like we were saying, so we're going to be finishing chapter 4 today. We're moving on for the First Amendment, and we're going to move on to the second, fourth, fifth, sixth, eighth. I know we have several that we're going to cover, but I can assure you that they're not going to take as long as the first, because the first had so many of those rights within them, right? You know, freedom of speech, freedom of the press, freedom of religion. So there were several of those important rights that we needed to cover, but these next ones are not going to be as lengthy. So let's go ahead and start with the Second Amendment discussion. Yes, and we'll definitely get some good discussions here on this one, right? This one always has a lot of discussion when it comes to people's viewpoints regarding the Second Amendment, right? And it's something that I'm sure a lot of you all have, strong opinions about as well. Here, let me go ahead and share the screen so that way you all can follow along here. But yes, so we will do. Let's see, where is it? Let's see. Okay, hold on. Oh no, let me just share the entire screen. Okay. Okay, so let's get to the Second Amendment here really quickly. Now, the Second Amendment, of course, I'm sure you all are very familiar with. There's a lot of discussion about the Second Amendment. There's a lot of controversy surrounding the Second Amendment. And there's a lot of reasons as to why the Second Amendment does tend to be very controversial. A lot of it is because of the wording, right? The wording can derive different interpretations from different people, right? The idea of a well-regulated militia, the right to keep and bear arms shall not be infringed, right? It's pretty much, the quick summary of what the Second Amendment discusses, right? And of course, the other aspect of the Second Amendment is because of what it deals with, right? It deals with, firearms um, and of course, firearms have been in the news a lot. I mean, even before a lot of these mass shootings, right? Because of the capability of what firearms can do, right? It's obviously something that requires a lot of, it requires safety. It requires a lot of, respect for the weapon and things like that. So that's why the emotions are always high whenever we talk about the Second Amendment because of what it represents and the capabilities of the item that it's talking about, right? Now, what we're going to talk about here is we're going to talk about how, and there's a good video that I have, which discusses the history of the Second Amendment, right, where it talks about how that the Second Amendment was originally constructed as part of the back and forth negotiations between the Federalists and the Anti-Federalists. The video talks about how that one of the points of contention of disagreement that the two groups had was, what do we do about a standing army? Because remember, going back to chapter 2, and we talked about Shays' Rebellion, right? And how because there was no standing national army, the federal government couldn't do anything to quell the rebellion going on in Massachusetts, right? They needed the state militia to step in. So the Federalists were wanting to construct a national army that would be able to defend against foreign aggression, as well as any threats, foreign and domestic, right? But the Anti-Federalists, again, they were very weary about this. They did not want for the federal government to have this much power. So the Second Amendment, because originally the way the Anti-Federalists wanted it, and the video talks about this, is that while the Federalists wanted a standing army, the Anti-Federalists wanted the different state militias to band together and form a united national army, so to speak, right? Not led by the national government, but comprised of the 13 different state militias, right? So it would require that extra step, right? If, let's say, the United States needed to go to war with Great Britain again, the Anti-Federalist idea would be like, okay, we're not going to have a standing army. We're going to have 13 militias, and then they'll band together and form, a de facto national army. And then once the threat is over, the militias will separate and go back to their states, right? So the Anti-Federalists wanted that extra step added, for the standing up, that where it would be the states that would have them, right? But ultimately, this idea gave way to the Federalist idea of just having a national army. But the Second Amendment was introduced as a way to to fight back against the threat of tyranny by the national army, right? To where the citizenry would be armed against against the national government type of thing, right? That's kind of a brief overview of the historical aspect of the Second Amendment. Now, that's where some of the controversy comes in, right? Because some people feel that the Second Amendment is, some people, again, people have different interpretations of it, right? Because it's not so clear cut, right? The Second Amendment does not necessarily say that this amendment is only valid during the 1800s, right? Or it only deals with state militias, right? It's ambiguous. So some people have opinions that some people feel that the Second Amendment is antiquated, that it's supposed to only deal with militias, and it doesn't necessarily mean, you know, that the common person is going to have these rights. But then the other side says no, the common person does have these rights, and they do have that right to be able to keep and bear arms, because it shall not be infringed. So they're making the argument that it should not be infringed on almost any circumstances. Now, the state and local governments can regulate firearms, often with different standards. This includes waiting periods, registration, types of arms allowed, and other aspects related to access, right? Now, the key word is here, right? Different standards, right? And also that it depends on your state and local governments, right? So that's why in some of your more blue liberal states like California and Illinois, they'll have stricter gun control laws, as opposed to some of these red states like Texas, which has the constitutional carry, right? Originally, you had to go get the license to carry, right? Which I went through that certification before. The way that certification operates is, in the morning, I did this a couple years ago, right? In the morning, you go do the classroom training where you go over like safety scenarios and things like that. And then in the afternoon, they take you out to a firing range so you can pass a weapons proficiency test, right? And then once you pass that, then then you can get the license, and you can. The reason why I didn't end up getting was because I didn't have time, because I had to send in the documentation to the state, and I had to send like a money order, so I just didn't have time. But now Texas has the constitutional carry where that's not even really necessary anymore. But again, but the reason why we mention this is because different states are going to have different standards. Now, there are some uniformity standards when it comes to like certain locations, like you can't take it into a courthouse and things like that, because obviously that becomes that's why if any of you have gone to the courthouse in Edinburgh, right, you notice that you have to go through the metal detector, right, because you can't bring firearms in there, for obvious, safety reasons, with the high ranking people, with the judges there, obviously, of course, we want to keep, those people safe, and just people in general safe. So they do have these regulations, right, when it comes to like safety. But again, the question about, do people have this constitutional right to carry, that question was answered in these two recent Supreme Court cases, in the District of Columbia versus Heller and the McDonald v. Chicago case. In both of these cases, and I was in grad school when these cases came out, so I vividly remember us having discussions in my class with my criminal justice professors about this topic, right? We were talking about, these recent Supreme Court decisions, they had just come out. And we were talking about how, what this means for the Second Amendment, right? So basically what it means is, as it says here, banning the possession of firearms in a home is not possible, because the District of Columbia and Chicago, which are, are blue areas, they had instituted handgun bans in those locations. And so the Heller case involved Mr. Dick Heller, who was an investigator with the DC Metropolitan Police. And so he wanted to take his firearm with him, because that's standard procedure, right? If you're in law enforcement, you usually carry your firearms with you at all times, because that's the nature of the job, right? So he wasn't able to do so, so he filed suit. The Supreme Court ruled in favor of Mr. Heller, saying that yes, that the Second Amendment does allow for people to carry firearms for their own personal protection at home, right? To protect yourself, to protect your property. You do have that right to carry. It's not just based on military service or a militia, right? The people can, carry for themselves, right? Now, this doesn't solve the issue, though, about people's interpretations of the Second Amendment when it comes to like the types of firearms, and of course, we because that's another issue when we look at the Second Amendment, right? Because some people have different opinions about, should people be able to carry any firearm they want to? Should it be limited? Should there be background checks, universal background checks that, and things like that? Should there be legislation that should restrict people's gun rights if, let's say, they've been convicted of domestic violence cases, things like that? Or maybe if they have been found to be, let's say a judge is also found to that, like let's say a judge has ruled that someone is, mentally incapacitated, so maybe they shouldn't have access to firearms because they might either cause harm to themselves or harm to other people. So there's a lot of questions to this, right? There's a lot of issues, right, in terms of the Second Amendment and the different meanings to it. That's why it's always so controversial when it's talked about. And of course we need to mention, the mass shootings that have been going on, right? there's been so many of them. I mean, I can't even lose track, right? I mean, it's just it seems like almost every other day there's always one of these, right? So it's just so with that being said, let's kind of open up the discussion for a little bit here. I mean, what do y'all think about the Second Amendment? I mean, what are some of y'all's thoughts on what what you all think about the Second Amendment issue? I mean, does anyone want to share anything about this one? What do y'all think? What do y'all think from what we discussed right now? And what y'all think? Okay, Ella, go ahead. Let me stop the share real quick. Go ahead.
I personally feel that the Second Amendment should be updated to reflect modern day firearms.
Okay, so you feel that because of the way the firearms are now today, right? That there should be some updating to it. Is that what you're saying, or?
Yes, absolutely.
Okay, right. And yes, and that is a very valid and common argument, right? Because the argument is that, you know, back in the 1700s, the types of weaponry is not what it is today, right? Where you have these AR-15s, these Kalashnikovs, these AK-47s, right? And the semi-automatic weapons, which in the 90s, we did have legislation that was passed. You can look this up. This was passed in 94. It dealt with the banning of certain types of semi-automatic weapons, right? Um, that expired though in 2004 during the Bush administration. But yes, in the 90s we had passed some of this gun reform here. Um, but yes, because that's kind of the key issue, right? Is the types of firearms, right? Does the Second Amendment mean that you can buy as many as you want, all kinds, or should there be limits to it? And as you said, the Second Amendment doesn't really give, from what it says, right? It doesn't really give anything. So you would say that it needs to be updated to reflect the modern capabilities of the firearms that we have today. Is that pretty much what you're saying as well? Okay, okay, Elizabeth says yes. Okay, very good. Okay, sounds good. Anyone else have any other thoughts on this? Anybody, any other thoughts on the Second Amendment issue? There definitely should be stricter regulations. Okay, Hazel agrees with stricter regulations. Yeah, yesterday I was watching on the news that there was a rally in Austin at the Capitol where they had families of the Uvalde shooting were there, and they were, because right now the Texas legislature is in session right now, so they're protesting because they're wanting for the legislature to work on some gun reform, right? But yeah, no, this is something that's been going on for, I mean, I think the first one, not to say that there weren't these mass shootings before, but the Columbine one is when we really started to pay attention with these. I don't know if you're all familiar with the Columbine High School shooting. This happened in the late 90s. I was in high school when that happened, and I remember hearing about it and talking about it in our high school classes, and so, there's been so many of those since then, right? I mean, even in Texas, we have, as I said, yes, you're old enough. Okay, yes. So you know what I'm talking about. Yes, the Columbine shooting, right? So because unfortunately we've seen that there's been so many of these in the schools, right? I mean, not just Uvalde, but we've had Santa Fe High School in Houston, several in Texas, right? We've had them in churches, right? Like Sutherland Springs. We also had the one in South Carolina, the Charleston, South Carolina one, the El Paso Walmart. I mean, it seems like I mean, let me just say that like before the pandemic happened, when I used to go to church, I actually would have to plan out what I would like, what my escape route would be. Like, if I was, if I was going over there to mass, I'd be like, okay, that's the nearest exit. So if somebody comes in, I got to get down, and things like that. So, you have to think about these things, unfortunately. Um, but are these things that we should have to think about? I mean, I don't know. These are definitely very important issues that we definitely need to discuss here, right? But yes, everyone, yeah. So the takeaway that I want you all to take from the Second Amendment is just that according to the Supreme Court now, with these recent Supreme Court decisions, you do have the right to carry firearms for your own personal protection. Of course, there are certain areas where they're still restricted, but you do have that right to carry. But again, as I always like to tell my class, this issue has been debated for 250 years. I don't think we're going to solve it here in this class, right? If we did, if we did, I don't think we'd be here, right? We'd probably be in Washington trying to get some of this stuff passed, right? If we did have the solution. So it is what it is. We'll keep seeing how this goes, but yeah. So it's definitely. But that's what I want. That's the takeaway I want you all to get from is the the current interpretation that we get from the current Supreme Court here. So, okay, so with that being said, let's go ahead and continue. Let's talk about due process here really quickly. Okay, so anyway, so let's talk about due process here. Okay, and like I said, these will go much faster here. So. Okay, so the idea of due process of law. This refers to the right of every citizen to be free of arbitrary action by national or state government. And we kind of talked about this a little bit before. This idea that it shouldn't matter what your race, gender, ethnicity, any of that stuff, that the law should apply equally to everyone, and you should have the ability to have your day in court, so to speak, right? That the government is not going to just, lock you up and throw away the key, right? That you have the right to be able to contest what the government is accusing you of doing, right? You have that right to an attorney. You have that right, against unreasonable searches and seizures. If the police need probable cause, the search warrant backed up by probable cause in order to conduct searches, right? They can't just do spot checks just to make sure that you're not doing anything wrong, right? So that's what this whole process of that's what the process of due process of law is, right? This whole idea that the government has to have a reason for why they're going to take action against you, and it has to be fair, it has to be just, and you also have rights within the process. If you're going to be going to prison, the government better make sure that they've dot their I's and crossed their T's to make sure that you have done this. And so the burden of proof is on the government, right? We're kind of talking about a little bit of some legal terms, right? Beyond a reasonable doubt, right? Some of y'all probably heard that phrase, right? That when someone is going to go to trial and they've got a jury trial, that the jury has to decide beyond a reasonable doubt, right? That the burden of proof is on the government to prove that you did something wrong, not on you to prove that you didn't, right? The innocent until proven guilty phrase, right? That's the legal doctrine that we follow in this country, right? It's the government's role to decide. What that means here is that, let's say you have a situation where if you're on trial and it's not necessarily that you didn't do it, that's why I don't like to use the phrase innocent. It's supposed to be either guilty or not guilty, right? So for all we know, you may have done it, but if the government doesn't do a good enough job of convincing the jury beyond a reasonable doubt that you did this, then the jury has to go not guilty. Doesn't mean that you didn't do it. It's just that the government did not make a strong enough case. The government did not bring up enough evidence. So if the government didn't bring up enough evidence, then you have to go with not guilty, right? So that's the legal doctrine that we have when it comes to criminal law and criminal procedure here, right? So we'll take a look at these amendments, and the Fourth, Fifth, Sixth, and Eighth Amendments taken together are the essence of the due process of law. So let's kind of dive into these. Okay, let's go to the Fourth Amendment really quickly. Excuse me. So the Fourth Amendment guarantees the security of citizens against unreasonable, improper searches and seizures, right? So again, just to kind of, to reiterate this again, that if the government is going to conduct a search, it has to be reasonable. Now, we are going to take a look at, what this means, and also how there's some scenarios. A lot of this is like law school type of stuff, because again, I've never gone to law school. I wanted to go, but it's really pricey. And again, just like with getting my PhD in political science, I'm not going to go and give up my job to go be an attorney. Maybe I'll do it when I'm retired. We'll see. Or unless they have an online program, maybe I'll do it then. But the point here is that, I have a lot of friends who are attorneys, and they talk about how that a lot of law school is a lot of scenarios where they go over a lot of cases and they discuss the cases and they talk about, why was the case decided the way it was? What was the legal doctrine that was used to decide this case, right? And so we're going to kind of do a little bit of that here as well, a little bit of these scenarios. So the exclusionary rule is what affirmed the Fourth Amendment, right? So the ability of courts to exclude illegally obtained evidence in Mapp v. Ohio. Now, the Mapp v. Ohio case is pretty interesting, right? This is a case where you had this woman who was believed to be involved in, some racketeering going on in Ohio, and they were looking for, bomb making material, at her house, and so they showed up with a paper that was not a warrant, and she did not let them in. First they showed up to her house, and then she said, no, you don't have a warrant, so you can't come in here. So she knew her rights. Then they come back with like a flimsy paper warrant type of thing, something that wasn't valid, and they come in and they don't find the material that they're looking for, but they do find some illicit pornographic material, which at the time was considered illegal. So she gets arrested for that. She files suit, because she's claiming that her Fourth Amendment rights were violated, and the Supreme Court did agree, right, that any evidence that is obtained illegally, illicitly, can be excluded from a case, right? So so in this case, the illicit material was excluded, so there really wasn't any case against her, right? Because that's what they got her for. Now, there are some exceptions to this, right? So this does not mean that the police need to always have a search warrant, right? Now the proper procedure is that the police do need to have probable cause, right? And of course, there's different levels to that, right? In terms of how much probable cause do you need in order to be able to, go to a judge or a magistrate to be able to get a search warrant, right? So you have to be able to continue to build up your case, build up evidence, build up, testimony, do your investigative work. And then once you have enough of that, then you can go to a judge and you can request for a search warrant. Now, once the judge grants a search warrant, the search warrant has to be very specific in terms of what they're looking for, where they're going to do the search, and the time also. You can't just have a general warrant where just be like, okay, the judge says we can search everywhere, we're going to tear up the whole house and look, like they kind of make fun of that, like on The Simpsons and other shows and things like that. But the idea is that the search warrant is supposed to be very limited. So a good example would be like, if let's say, you're looking for a stolen car, right? You're not going to go and, the search warrant is going to be usually confined to the garage, because that is reasonably where you would think that a car could be, right? Or maybe they have it like parked in the backyard or something like that, right? You're not going to go and look in the kitchen for a car, because the car can't fit in there, right? Now, what you all also have to remember, everyone, is that these warrants and investigations are fluid, so to speak, right? So let's say they get to the garage, they find the stolen car, but then they find other things. Let's say they find, drugs there in the garage. Now, they didn't know that when they were going to conduct the search, but because now they see it, now that builds on the investigation, and now they can go and search other areas, right? Because if they've got drugs there, they could have drugs in other parts of the house, right? Now that's something where the search can expand. I don't know if that kind of makes sense, right? It's the same logic to where, like, let's say the police pull you over for speeding. And I don't know why you'd be stupid to do this, but let's say they pull you over for speeding, and an officer walks up, gonna ask for the registration information, because they're gonna give you a ticket for speeding, and then they see that you've got drugs in the passenger seats. Now the question is, do they need a search warrant for that? Even though they didn't know you had drugs in the seat, but they don't need a search warrant, right? Because they saw it in front of them, right? That's called the plain view doctrine, okay? So there are exceptions to the exclusionary rule, right? To where you don't need a search warrant for everything, right? There's also what's called inevitable discovery, where if the police can make the argument that they would have found the evidence even without the search warrant anyway, so then that can be allowed, right? But again, that's up for a judge to decide. So there are some exceptions to this, right? There's also some other cases such as U.S. v. Grubbs and the U.S. v. Jones case. The court ruled that the police could conduct searches using the anticipatory warrants. This, of course, this was a case dealing with it was a sting operation against child pornography, and so and some of y'all are probably familiar with some of these cases, right? It's like the whole, like, To Catch a Predator, like and they set up the sting operations, and then they end up going to the house and things like that. So it was something similar to where they had one of these offenders had requested child pornographic material, and it was going to be sent to the house, but it hadn't got to the house yet. But the fact that the offender had already made the request was already enough, so to speak, right? So that's why it's considered an anticipatory warrant. It was anticipating the the tape getting there, right? So they were making the argument that because they had already engaged in the criminal act themselves. There's also the U.S. v. Jones case. The court ruled that prosecutors could not attach a global positioning system device to a vehicle to monitor a suspect. So a lot of these questions that are coming up here when it comes to the exclusionary rule deals with new technology that's coming up, right? So obviously, of course, the framers had no idea. They couldn't fathom GPS. They couldn't fathom cell phones. They couldn't fathom these things, right? This was beyond their comprehension. But that doesn't mean that the Fourth Amendment does not still apply to these items. So what the courts have to do is they have to say, okay, so if the framers were alive today, how would they view GPS monitoring? How would they view locked cell phones? And so the court ruled in the Jones case that you can't attach a GPS and try to get get information that way. With this case, this was a situation where they were trying to get this supposed drug dealer, right? They wanted to get more evidence because they saw that he was driving around, and they wanted to try to get more evidence to try to position where he was at, right? So if they attached the GPS system, they could find out where he's been, the times he's been, the houses he's been, and things like that. But you can't do that. You can't do that preemptively, right? You have to gain more evidence, right? You have to, because the problem with the police was they didn't have enough evidence to do this in the first place, right? You can't use the GPS just based on a hunch and then get your evidence that way, right? You have to get the evidence first, right? So that's why the court ruled that they could not attach the GPS. Now, there's also some of these other cases. Let's see, where's the they don't have the California v. Bradley case. This is another one. So changes in technology have impacted jurisprudence of the Fourth Amendment. So the Maryland v. King and Riley v. California cases dealt with DNA testing and cell phone contents here, right? So specifically the Riley California case. This one, I vividly remember this one because this was in 2014. I was driving home. I was driving home from my Laredo elementary teaching job. This was right before I became a high school teacher. And I was like, "Ooh, this is interesting. This is right up my alley." So the question in the Riley versus California case was, can the police unlock your cell phone to try to gain information? Because what was going on at the time was, again, another drug dealer. They wanted to get into his locked phone because they wanted to see if they could find the contacts for, they wanted to get into his contacts, right? Because they wanted to see if they could link the contacts with the people that had bought drugs from him. But the problem was that the cell phone was locked. So let me ask you all this question really quickly. Would the police still need a search warrant if the cell phone is locked? What do y'all think?
Yes, they still need a search warrant.
Yes, exactly. And that was my first reaction too. I was like, well, if it's locked, it's locked, right? Just because it's just because it's a digital device doesn't mean that just because it's not a physical lock doesn't mean that the item is still locked, right? So yes, exactly. That's an example of the Supreme Court using the logic and reasoning from before to apply it to new cases, right? And then the Fourth Amendment also challenges have been raised against aggressive police tactics such as stop and frisk. So another Ohio case, the Terry v. Ohio case, another case that we talked about a lot in criminal justice classes. So the court ruled that if an officer had probable cause to believe a person was armed, a search was permissible. So the issue, so stop and frisk is basically a safety technique that officers can use in order to protect themselves when it comes to confronting an individual. So basically what stop and frisk means is, let me explain the situation. So in the Terry v. Ohio case, you had a situation where you had this guy that was on the street and it looked like he had a gun like in his pocket, right? So the police officer, before they confronted him, they did a pat down search to check to see what that was in his pocket. So they found that it was a gun. So the officers can conduct a stop and frisk for their safety, right? They can say, okay, we're gonna pat you down, for all of our safety involved. Now, there is controversy with this, right? Because some people have, and you can look this up on the internet, right? There's been a lot of articles and research that's been done on this because of the way stop and frisk is used, right? Some people have made the arguments that it targets minority groups disproportionately. People that are in certain neighborhoods are more subjected to stop and frisk. So again, I'm not trying to. Again, I understand the notion of stop and frisk. I understand that, and this is why sometimes police officers will also handcuff someone, not that they're under arrest, but just to defuse the situation. Now, again, that's also very controversial, right? Because some people might feel like, well, I haven't done anything wrong. Why are you doing this to me? So, again, I'm not trying to say for sure, right, in terms of, whether whether we agree or disagree on this. I'm trying to explain why it's done but the issue is how it's used, right? I think that's the main issue, right? Is how it's used. Is it used responsibly? Is it used simply for officer safety, or is it being used for other reasons? It's also, again, kind of similar argument to what we've seen with a lot of the, Black Lives Matter movement and a lot of the protest and the agitation against, lethal use of force, right? And how is the lethal use of force? Is it being used? Does the situations where it's been used, is it being called for, right? Is it something where the officers maybe could have done something else, right, to maybe try to handle the situation differently, right? Again, I'm not trying to say one way or another, right, because it's a very complex situation, but there certainly is attention being brought to this because of who is being targeted and the situations that have been going on, right? I mean, of course, the George Floyd situation, right? I mean, there's no excuse for that one, right? Obviously, of course, that was something that was obviously, very heinous and things like that. But in terms of some of these other cases, some of them are a little bit more difficult to kind of, gauge and judge, so to speak, right? So there's been a lot of, and so that conversation will definitely continue in terms of, the some of these events and incidences, right? So, and again, we'll talk a little bit more about Black Lives Matter a little bit later in the next chapter here. Okay, so let's move on now to the Fifth Amendment. Okay, any questions on the Fourth Amendment before we continue? And so just also note that there's there's way too many different circumstances. I mean, this is not a law class, it's not a law school class, so we could go over so many more of these. But yeah, this is just kind of a brief overview on the Fourth Amendment. They've got classes devoted to the Fourth Amendment. Let's talk about the Fifth Amendment now, really quickly. Okay, the Fifth Amendment covers the right to a grand jury, and protection against double jeopardy and self-incrimination. So the right to a grand jury, the grand jury determines whether sufficient evidence is available to justify a trial. Now, the purpose of a grand jury is, because whenever people think of juries, they always tend to think of like the trial juries, right? The people that decide whether someone's guilty or not guilty. Those are the juries that happen at the end of, the end of a trial. The grand jury happens before a trial starts. The grand jury is responsible for determining if there's enough evidence to indict someone, to bring them forth before a judge, right? To justify a trial, right? Where, I've never been on a grand jury, but I've seen it occur before. It's really interesting in terms of, how, and obviously not the proceedings because that's secret, right? The proceedings are secret to where that's between the grand jury and the prosecution, right? The prosecution will present the evidence. They'll request for the grand jury to issue the indictment, and then I just went and just took down the information, right? When I used to work at the courthouse. But it is interesting, right? It is interesting to see like when the grand jury goes and makes their decision whether to indict someone or not. But that's the whole notion of the grand jury, right? The idea is that you want to have the community decide whether whether there's enough evidence, not just for the prosecution, but also for the grand jury to also get involved in this as well. We also have the protection from double jeopardy, which is at the heart of the 37 Palco case, like we talked a little bit about before. The person cannot be tried twice for the same crime. A good example of this I always like to use is the O.J. Simpson case from the 1990s. I know I'm kind of dating myself again here, but I think people still talk about it today. O.J. Simpson, of course, this was I was a little bit too young to actually like really understand what was going on. This was happening in 94, I think, or 95, something like that. So I was still in elementary, so I really wasn't like too aware of trials and and things like that. So but I did watch a little bit of it and I thought it was interesting. Of course, for those of you who are not familiar, right? What happened with O.J. Simpson is that he was arrested for the murder of his ex-wife Nicole Brown Simpson and her friend Ron Goldman, right? So he was they had the chase there in LA, with his Bronco and all that. So we had the trial, and of course he had a lot of the top attorneys like Johnny Cochran, as the Shapiro as well, Kim Kardashian's dad. He was also an attorney, so he was there on the defense team for O.J. Simpson, right? So O.J. Simpson was found to be not guilty, right? To make a long story short, and of course there was a lot of controversy, right? Because there was a lot of DNA evidence that was linking him, but of course we also had the glove that didn't fit, that Johnny Cochran famously said, if it doesn't fit, you must acquit. So That's always like, kind of the takeaway from the O.J. Simpson trial. But the point is that O.J. Simpson was found to be not. The LA County District Attorney's Office, there wasn't anything they could do about that decision, right? If the jury finds someone to be not guilty, then they're not guilty, right? They can't try them twice for the same crime, so to speak, right? So that's an example of double jeopardy. Now, that doesn't mean that there aren't other violations, right? Because afterwards, O.J. Simpson was then sued by the Goldman family, and in the lawsuit, he was found to be liable, right? Because in a civil case, the level of evidence, I'm sorry, the level of proof needed is called the preponderance of the evidence, right? So that's a much lower standard to meet than beyond a reasonable doubt, right? Um, so they didn't meet the standard on the criminal case, but in the civil case, he was found to be he was found to be civilly liable, and so that's where he had to pay all this money. He had to sell his Heisman Trophy, and that's why he tried to get it back several years later in that plot in Las Vegas, and he was found to be guilty there, right? Because he was involved in like criminal conspiracy and all that stuff. But I think he's already out of jail or out of prison. Sorry, but yeah, so that's double jeopardy right there. Protection from self-incrimination. Now, this of course is the Miranda rule, right? I know all of you all are very familiar with the Miranda rights, right? They always say it in the cop shows, right? So the Miranda rule requires that prior to police interrogation, persons who are under arrest must be informed of their right to remain silent and to have the benefit of legal counsel. And we're going to talk about legal. Let's talk about legal counsel right here in a bit, and then we'll come back. Of course, this is an example of the Miranda warnings here. Let's come back. We'll come back to Miranda right now, but let's go to the benefit of legal counsel because I want to tie it in here because the right to remain silent, of course, goes to the Fifth Amendment, right? The idea against self-incrimination, right? Where you have that right to not say anything, right? If the police are going to interrogate you, you don't have to say anything, right? You can remain silent because the Miranda ruling is the Miranda rights, of course, it's you have the right to remain silent. Anything you say will be used against you. You have the right to an attorney. If you cannot afford one will be provided to you, right? So okay, well let's talk about the attorney first, and then we'll tie it in together. So the Sixth Amendment includes the right to counsel, a speedy trial, and an impartial jury. So let's talk about Gideon versus Wainwright, and then we'll come back to Miranda. So in Gideon versus Wainwright, 1963, another famous criminal justice case, people facing imprisonment have the right to an attorney even if they cannot afford one, whereupon they will be appointed a public defender. So the case involving Gideon was Gideon got arrested for he got arrested for he got into a scuffle at a pool hall, and he was found to be guilty. Now the issue with Gideon in his case was that the charge against him was not a major charge, right? I mean, it was sort of major, but not that major. So in Florida, they had a law where the only, that your right to an attorney was only for major felony cases, right? So because Gideon was kind of like caught in the middle here, where it wasn't that serious, but it was serious enough for him to go to prison for a couple of years, he was not allowed to have an attorney. So he filed a lawsuit. It got to the Supreme Court. It's one of the most famous ones, right? Because he wrote it from his prison cell, right? So it got to the Supreme Court. The Supreme Court took it up. He was also represented by one of the famous legal attorneys at the time, and they do this, right? Attorneys will take cases not necessarily because of the personal circumstance involving Gideon, but because of the constitutional issue involving Gideon's case, right? The case wasn't taken because of what he did in the pool hall. It was because of the constitutional issue, right? Should he have had an attorney? And the Supreme Court did rule that yes, that any case involving any situation where if you're going to have to go to prison, you do have that right to an attorney. Okay, so that's what Gideon versus Wainwright ruled, right? So in Gideon's case, he should have had an attorney because he was facing prison time, even though the prison time wasn't that much. He was facing some prison time, and so the Supreme Court did rule that he did have that right to an attorney, right? So, and again, of course, the idea is that a lot of these people who are in the legal system and are needing attorneys probably can't afford one, right? Because there is that link between, I mean, it's not all the time, but people who are kind of on the lower end of the socioeconomic scale are going to be more susceptible to criminal activity, right? Because for for socioeconomic reasons, things like that, which again, that's more like sociology. But the point is that the people who are, unfortunately, the people who are going through the criminal justice system usually are the ones who can't afford attorneys. So now we have what are called these public defenders. Let me just take a swig of water really quickly. The public defenders are attorneys that are hired by, it depends on jurisdictions. And here in Hidalgo County, they work for the county, right? So we have the county public defender's office. These are the people that, that work for the county, and they will take cases for the people who can't afford their own personal attorneys, right? Because attorneys are very expensive. So that's what the public defenders are. We talk a little bit more about public defenders in Texas government. We talk about some of the issues with the public defender system, in that are these accused getting the best quality attorneys? Because unfortunately, a lot of these public defender attorneys are usually, these are kind of like the green attorneys coming straight out of law school, and they're trying to gain experience so they can move into private practice, because private practice pays a lot more. So are these people kind of getting the same type of justice, so to speak? You know what I mean? But again, that's more for Texas government, right? But it's something to definitely think about, right? And so rights counsel has been expanded, and most states and cities employ these public defenders. Also extends beyond trials for serious crimes that, with or without a jury, may result in imprisonment, right? So again, this is the issue that was going on with Gideon, right? Because it was serious enough to where he could go to prison, even if it was just for a little bit. He still was entitled to the right to an attorney. Now, with that being said, let's go back to Miranda. So again, so the issue with Miranda was that he was involved in another another situation where up there, and no, he murdered someone, right? I think he murdered someone. So the issue with Miranda was that he was arrested, but he didn't know what his rights were, right? Like he wasn't, the issue was he didn't know that he had that Fifth Amendment right against self-incrimination, right? Because the thing with Miranda is that that information is so incredibly important that you need to know what your rights are when you are going to be involved in the criminal justice system, right? As I mentioned when we first started this discussion, right, a couple of class times ago, right? When your rights are being restricted, when you're under control of the government because you've been accused of something, your rights are restricted, right? You can't go home. You're under control of the government. So the government has to provide that information to you that, hey, you're under arrest. These are what your options are. This is what the process is going to be, and this is what you can do within this process. The Miranda ruling, in which the Supreme Court ruled, in favor of Miranda, was that these rights are so important that you have to be informed of them. You have to know what those rights are. You have to know that you can remain silent. You have to know that you have that right to an attorney. Because again, if you don't know these things, then the government could take advantage of not knowing your rights and things like that, right? So the government can, so you have to know what your rights are when it comes to the criminal justice system. Which I also, again, this is kind of like my own personal take. I also would like to see the Miranda rule extended to like requests for searches, but that's a whole other story, But because in that case, if an officer asks like, can they search, that I would like to see them say, just know that you don't have to consent to that search under the, under the Constitution. I would like to see that because not everybody knows their rights. But anyway, that is what it is. So, with that being said, okay, so does everyone kind of understand the Miranda rule, right, and why it's important, right? That you need to have that information beforehand, right? Because if you need to know that you can have an attorney, so you can be like, hey, okay, I'm not gonna say anything. I want my attorney. Where's my attorney? Get me my attorney. So that's why it's important for in this case, as we mentioned, for people to know their rights. So okay, anyway, let me check the chat really quickly. So it's not what you did, but what you can. Yeah, right, exactly. That's true, right? That it's. I heard that in a movie one time, right? It's not what you know, it's what you can prove in court or something like that, right? Because it's true, right? That the government has to be able to prove that, right? Even if it did happen, but if the government can't prove it, oh, it's a Feel Good Man. Okay, that's the movie. Okay, got you. Okay, good. I haven't seen that movie in a while. I need to. That's the one with was the Tom Cruise and Jack Nicholson, I think, right? Yeah, I need to see that movie again. But yeah, no, exactly. It's that's definitely very true, right? The whole notion of that even if somebody did something, if the government can't prove beyond a reasonable doubt, then then the jury has to go with not guilty, and things like that. So yes, absolutely, very true. Okay, so let's finish off really quickly. Let's go with the Eighth Amendment really quick, and then we'll talk about the we'll talk about the Eighth Amendment really quick. Okay, so let's talk about this really quick. Okay, so I'm sorry, I wasn't sharing. Let me share again. Hold on. Okay, just a moment. Oh, I was sharing. Okay, good. Okay. Okay, so the Eighth Amendment, of course, lastly we'll talk about here, prohibits excessive bail, excessive fines, cruel and unusual punishment. So this, of course, is very straightforward when it comes to the excessive bail and excessive fines, right? That if you're good, like let's say you get arrested for stealing something from HEB, right? Let's say you want to go get a beer run or something like that. They're not gonna like give you like $1 million bond, right? Because obviously what you did wasn't really that bad, right? The punishment has to fit the crime, so to speak. You're not gonna just lock somebody up, and send them this excessive bail, right? Which by the way, let me also explain what bail is, right? That bail is if you get arrested, you can post bail so that you can stay at home until your trial, right? So if you don't want to stay in the county jail, you can post bail and then you can go home until it's time for you to actually have your trial, so to speak, right? As well as the excessive fines, right? That you can't just again you can't have it. The bail can't be like $1 million, right? If it's something small. The cruel and unusual punishment. This is the one that gets talked about a little bit more, right? Because this is a little bit more murky, right? What is cruel and unusual punishment? People have different interpretations of it. So some people feel that the death penalty is cruel and unusual. And we'll talk about this a little bit, right? So most debate has focused on what is considered cruel and unusual punishment, right? So the states decide whether to allow the death penalty, and if allowed, the states determine the execution method or methods. Now, so again, this is a question, right? This is a question that this is one of the it doesn't get talked about as much as some of these other issues, but it's still something that gets talked about, pretty regularly. Are people for and against the death penalty? Because some people feel that the death penalty is cruel and unusual. Certain states do, certain states have outlawed the death penalty, like in your more blue liberal states like California, New York. That's why I think I mentioned in this class, right, that the guy who went and killed people in that Buffalo supermarket, he got life in prison, because New York does not allow the death penalty. If he did that in Texas, he probably would have gotten the death penalty, right? So it depends on your red, more conservative states are going to be, they're going to have the death penalty, and Texas has the most execution, which makes sense because Texas is the second highest populated state in the country, and it's the most populated state, that tends to be conservative. But again, the question that the Supreme Court has ruled is not necessarily that the death penalty is cruel and unusual, but the method that we use. That's why we don't have like we don't have like public hangings anymore, right? Like back we had like in the 1800s where I don't know if you all read like in history books where they're gonna go hang someone. They would treat it like a carnival event. It was like a something like a county fair type of thing. Like it was an attraction, right? So obviously, of course, we don't do that anymore, right? We don't allow for public hangings. The execution is private. It's not something that's open to the public, right? It's something where it's just involves like the families and things like that. We've also, of course, decided that certain methods are also, considered cruel and unusual, right? Like again, that's why we don't have hangings, right? Mostly states use, the lethal injection, right? That's usually what they tend to use because they want to try to make it as humane as possible, so to speak. So does that make sense, right? That the issue, and again, and some people, of course, have disagreements on this, right? But the other issue is not just whether the death penalty itself is cruel and unusual. That's more open for debate. But what's not really open for debate is the methods that are used, right? We want to try to make that method, if you're going to use that, if you're in a state that does execute criminals, that you're going to do it, humanely, right? And the Supreme Court has also ruled that only murder can be used. Execution can only be for murder, right? Not for anything less than that. So if it's, so if you're in prison for, robbery, armed robbery, you're not going to be subject to the death penalty. That's only for murder. Okay, so last couple of things. Let's see. Let's go to right to privacy really quickly, and then eminent domain, and then we'll stop here, right? So the right to privacy can be summarized simply as the right to be left alone. The right to privacy is not explicitly mentioned in the Bill of Rights. This right has been interpreted as resting in the Fourth Amendment. Let's see if we have enough time. Yeah, we got 2 minutes. Let's cover this really quickly. So the framers of the Constitution were aware of government intrusions into private homes, often for papers or books encouraging political discontent, right? So the right to privacy, again, it's not necessarily mentioned in the Bill of Rights, but it flows from the Fourth Amendment, right? The idea is that if the government needs a search warrant to go to my house, then the opposite is true, right? If they don't have a search warrant, then they don't have the right to be at my house, right? They can't just, they have to leave me alone, right? I am entitled to privacy in my own house if I'm not doing anything wrong, right? So this right to privacy, deals with that, but it also deals with some of these other cases, right? So eminent domain, of course, the government can take private property for public use. However, the Fifth Amendment requires a demonstration of public purpose as well as fair payment. So, eminent domain is interesting, right? Because with eminent domain, the idea is that the government can take your land if it's involving a public purpose, right? So an example would be like, let's say, they want, the government wanted to build, like, expand like the expressway, right? But your house is in the way, right? And you're saying, no, I'm not going to sell because I don't want to leave. The government can take your property because you can't hold up that process, of the public purpose. But the government does have to provide you fair payment. Now, of course, there's different interpretations on what fair payment means. Usually, it just means the market value of your house. But some people might be like, well, but there's sentimental value here, right? I don't want to leave. I don't just want an equal swap, right? I want to be compensated for having to leave my house when I wasn't going to leave, to begin with, right? So that's also somewhat controversial, right? But the Supreme Court has ruled that pretty much fair payment is just the monetary value of your house, even though some people disagree with this. The right to privacy covers controversial matters such as birth control, abortion, which again we're going to have to update this a bit, right? Because we've got the Hobbs case, right, that overturned Roe versus Wade. But the birth control case, this of course was the Griswold case involved. Could the government, ban birth control, right? And the courts ruled that they couldn't, right, because that's a personal issue. Same thing with abortion, right? Originally, the Roe versus Wade decision was, the justices ruled, especially Justice Blackmun, who wrote the majority opinion in this case, he ruled that it's not the government's business to be weighing in on, a personal decision between a woman and her doctor, right? That, of course, is where the decision came from, right? In recent cases, have limited the right to regulation by states, including the Hobbs case, which overturned Roe versus Wade. Which again, it'll be updated in the next book. And then sexual orientation, Bowers v. Hardwick in 1986, and overturned by Lawrence v. Texas. The Lawrence v. Texas one is interesting, right? Because this I also was in college when this happened in undergrad. This was the case involving Texas having the anti-sodomy laws, where there was laws in the book in Texas where homosexual behavior was banned, right? And so you had a homosexual couple that was arrested for the sexual relations they were having, there in the privacy in their own home, right? So they brought it to the Supreme Court, and the Supreme Court ruled against Texas, right? That you can't be passing laws dealing with people's private, private matters, so to speak, right? So that, of course, goes to this whole idea of, right to privacy. So, okay, so let's go ahead and end here for today. So does anyone else have any other questions before we end for today? I hope that made things, we had a pretty good, interesting discussion here. I know I would have liked to have talked a little bit more about some of these topics and issues, but I wanted for us to I didn't want to continue chapter 4 next week because we definitely have to keep moving on here. So, so next week we'll start on chapter 5, okay? Does anyone have any other questions before we end for today? Anything else? Elda, go ahead.
In regards to the right to property, does that also constitute that law enforcement cannot set foot on your property unless they have a warrant?
Well, okay. So again, it depends. So give me a little bit more information. And again, I'm not an attorney, so please don't take my legal advice, to heart. But well, let me stop the recording.